A number of important elements in Canada's federal privacy law turn on whether personal information is sensitive, which is a concept that the law does not define. Our law is principles-based, which makes it flexible and resilient, but does require a bit of a deep dive into concepts like this. In this recording, I plan to walk through the concept of sensitivity and how it applies in the context of our federal privacy law. Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGinnis Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. In this channel, I try to provide educational and informative content about Canadian privacy and technology law. You should check out the full disclaimer below, but you should know that this is a complicated area of the law with many nuances, and this is a general overview. The Office of the Privacy Commissioner of Canada recently released an interpretation bulletin on the concept of sensitive information. Though it's not legally binding, it does clearly set out how the Commissioner approaches this question and summarizes some of the OPC's key findings and court decisions that have applied the concept of sensitivity. Unlike some privacy laws outside of Canada, our Personal Information Protection and Electronic Documents Act does not explicitly categorize or define what personal information is deemed to be sensitive. Some laws have what amounts to a laundry list of types of data that require heightened protection or require notification to individuals if breached. We're left with some pretty general statements on what is sensitive, and it pretty clearly exists on a continuum. I tend to think this is actually a good thing, though it does require some in-depth knowledge of the statute and how it has been applied to fully get a handle on it. It takes into account that privacy is multidimensional, humans are complicated, and people have varying perceptions of privacy. Also, what is sensitive really depends on the context. Information in one context may be completely banal, but that same information in a number of other contexts may be considered to be very private and intimate information. This is all very important because at least three key elements of the Canadian privacy law turn on the concept of whether the personal information at issue is sensitive and how sensitive it is. These are the form of consent that a company has to obtain, determining what safeguards are appropriate to protect the information, and whether a company has to notify an affected individual in the case of a data breach. First, let's turn to the consent principle. Knowledgeable, informed consent is required for all collection, use, and disclosure of personal information, unless Section 7 of the Act says that you can forego it. What kind of consent you have to get depends on the sensitivity of the information. Subprinciple 4.3.4 lays it out and gives the best overview in the Act of the concept of sensitivity. It says, the form of the consent sought by the organization may vary depending upon the circumstances and the type of information. In determining the form of consent to use, organizations shall take into account the sensitivity of the information. Although some information, for example, medical records and income records, is almost always considered to be sensitive, any information can be sensitive depending upon the context. For example, the names and addresses of subscribers to a news magazine would generally not be considered sensitive information. However, the names and addresses of subscribers to some special interest magazines might be considered sensitive. So let's break that down a little. It's referring to the form of consent. This means whether it can be opt-out or has to be opt-in. Can it be implied consent, or does it have to be express consent? Also, should you have a clear record of it? The more sensitive it is, the more robust your consent has to be. So it can't be opt-out, it likely can't be implied consent, and if it's really sensitive, it should be in writing, clearly capturing what the person agreed and what it is that they agreed to. The next place this comes up is in Principle 7, the safeguards principle. Here, sensitivity is front and center and is the most important element of determining what safeguards need to be adopted. It says personal information shall be protected by security safeguards appropriate to the sensitivity of the information. Clearly, the more sensitive, the greater the safeguards have to be. This is a bit of a no-brainer for those in the security field. The greater the value of the thing you have to protect, the greater measures you should adopt to protect it. In privacy, the inverse is true as well. The greater the risk of harm to the individual or risk of liability to the organization if the information is compromised, the greater the safeguards should be. Again, this is entirely principles-based, so it does not tell you what particular safeguards you have to adopt if the information is sensitive. It just says the safeguards need to be appropriate in light of the sensitivity of the data. Finally, the concept of sensitivity comes up in the newly added data breach of security safeguards provisions in Section 10.1 of PIPEDA. Whether you have to report a breach to the Privacy Commissioner and notify the affected individuals depends upon whether the breach creates a real risk of significant harm. You have to take into account the sensitivity of the personal information involved in the breach, among other factors. We'll talk more about how the breach of security safeguards provisions are very helpful in considering the concept of sensitivity. So with all this, what is sensitive personal information? Well, that depends. It depends on the entire circumstances. Recall what Principle 4.3.4 said as general guidance. It says, although some information, for example, medical records and income records, is almost always considered to be sensitive, any information can be sensitive, depending upon the context. For example, the names and addresses of subscribers to a news magazine would generally not be considered sensitive information. However, the names and addresses of subscribers to some special interest magazines might be considered sensitive. So you have to ask, what does the data tell you? What is that data associated with? Your name may not be sensitive on your business card, but your name on a list of psychiatric patients is completely different. It's the exact same information, but the context in which it appears tells you a whole lot more. With that context, we have to ask whether it is something that people would ordinarily consider to be private. Is it about their intimate life? Can it be embarrassing or stigmatizing? Can it be misused to cause harm? And then we have to consider what sorts of harms. For this, we have some really good guidance from the breach notification rules. To consider whether a data breach causes a real risk of significant harm, Section 10.1 sub 7 lays out what sorts of harms have to be considered. It starts out with bodily harm. For example, the location of somebody fleeing intimate partner violence may cause them bodily harm. Then we have humiliation. So is it embarrassing? Then there's damage to reputation or relationships, which is self-explanatory. Loss of employment, business, or professional opportunities is similar. Financial loss, identity theft, negative effects on the credit record are harms that are often considered in the context of breaches involving financial information or information that could be used to impersonate somebody for identity theft purposes. And it ends with damage or loss to property. So this gives us a pretty good list of the sorts of harms that one would have to consider, which can help inform us about the idea of sensitivity. A good example of this is the fact that the Privacy Commissioner of Alberta has concluded in innumerable data breach notification decisions that email addresses are sensitive information. This seems counterintuitive since we give out our email addresses all over the place, but in the context of being on a list or in a group, that leads to an important inference, that the person whose email address has been compromised has a relationship with the person who is holding the list. So if a list of customers of a bank is acquired by a bad actor, that bad actor can use that list to send phishing emails pretending to be from the bank. It puts them at a risk of financial loss. If that list came from a dating website, it puts them at risk of damage to reputation or humiliation. So context really matters here. The OPC's guidance document that I referred to before has a good summary of cases and findings where the OPC itself or the courts have considered certain information to be sensitive. It includes the following examples: email addresses which can be used for phishing, health and medical information, financial information including social insurance numbers, health or exercise club routines. It notes the fact that you go to a gym may not be particularly sensitive, but what you do there can be. Information about sexual or intimate life or relationships, political interests or affiliations, biometrics, and I would add to that list location information, either current or historical, or both. From the point of view of a business that collects and uses personal information, many of its practices have to take into account how sensitive the personal information is. We don't have a clear yardstick or a calculation to determine sensitivity, but a review of the points I've just discussed should provide a lot of guidance to see where things fall on the sensitivity continuum. I hope this has been of interest. This is a complicated and nuanced area of the law with few bright lines, but hopefully this has provided an overview of the principles at issue and how to determine whether or how sensitive personal information is. If you have any questions or comments, please feel free to leave them below. I read them all and I try to reply to them all as well. Also, if you have any topics you'd like to see covered in a future video, please let me know that as well. If your company needs help in this area, please reach out. My contact information is in the notes. And of course, feel free to share this with anybody for whom you think it may be useful. Thanks for tuning in.